Trusts have been used for legitimate purposes, like in estate planning, but also used to hide money and avoid accountability. The Regulation of Trust Bill seeks to, amongst others, address shortcomings in the current legislation that enables trustees to evade accountability, constrain the Master of the High Court in exercising effective oversight over trust, address the lack of transparency in management and control of trusts. All of these can increase the risk of trust structures being misused for money laundering and other criminal activities. These are the proposed changes. Protection of vulnerable persons. When courts create trusts for children or people with disabilities, they must now verify that the trust is actually appropriate and that the person's interests are properly protected. Transparency. Trustees must now prepare annual financial statements and keep records for 5 years after they stop being trustees. This is to avoid creating a conducive environment for money laundering and other criminal activities. Stronger oversight. The Master of the High Court gets new powers, which includes compliance notices, administrative fines, and the ability to appoint investigators. Land reform, trust changes. The bill proposes that trusts should not be created to administer property received by any community from the state in terms of an agreement or in terms of any law. Compliance, obligations, and penalties. The bill empowers the minister to exempt trusts with no or minimal financial activity from preparing annual financial statements. Currently, the Act provides that a trustee who fails to lodge a beneficial ownership register with the Master of the High Court commits an offence. The bill proposes that such non-compliance be addressed initially through compliance notices and administrative fines, with criminal sanctions serving as a measure of last resort.
We get into negative rating by FATF, as you would know, and we are also dealing with the issues of making sure that those who are beneficiaries are well known and we also safeguarded. Let's take example of two kinds of trusts that are established under this law. You can have communal property or those that are given land back. They, instead of using the rightful legislation that is under land reform, the CPA, they then come to this trust, which is not a proper vehicle for doing that. Secondly, those that are, get into accidents or maybe medical legal issues, and they are awarded some benefits in terms of the damages. Then the lawyers will find that they open trust under this act, but then there tends to be some abuse in terms of the funds that are kept in this trust. So now this law does give some safeguards in terms of when the court decides to grant that trust to be opened by a lawyer, for example, a legal practitioner. So it has to make sure that it is the right vehicle. So we're trying to align and make sure that this trusts are now becoming properly regulated.
Open for public comment until the 11th of September. Diabo Seto, SABC News, Johannesburg.